members of the Judicial Council insisted that the next government be given the opportunity to consider the argument for the expansion in the number of Supreme Court justices, if at all necessary. Ladies and gentlemen, we have in our possession a letter signed by the President of the Ghana Bar Association, Yao Achampon Boafo Esquire, dated 29th April 2024 and addressed to President Akufo Addo. In this letter, the Ghana Bar Association objected to the clandestine approach by President Akufo Addo to appoint 5 additional judges to Ghana's Supreme Court, thereby increasing the number of judges on the Supreme Court to 20. President Akufo Addo, with the connivance of the Chief Justice, had sought to hide his attempt to further pack the Supreme Court under the guise of a proposal for a minimum ceiling of 20 judges on Ghana's Supreme Court bench. The GBA's disagreement, which we find well-grounded and well-reasoned, is premised on the fact that the present proposal should have come in the form of a proposed amendment of Article 128(1) of the 1992 Constitution to set a new ceiling for the number of judges on the Supreme Court, which currently consists of the Chief Justice and a minimum of 9 other justices. The GBA argued forcefully that the request by President Akufo Addo and Chief Justice Gertrude Tokonu to increase the minimum number of justices of the Supreme Court to 20 will lead to the circumvention of the required constitutional amendment, hence their rejection of same. The GBA proposed a review of the constitution of the conventional number of justices of the Supreme Court every 10 years, calling for broader consultations with other key stakeholders such as the Council of State and Parliament. From the foregoing, it is clear that the Chief Justice sought to put forward the names of these judges as though they were being proposed by the Attorney General on behalf of President Akufo Addo. We are completely shocked and scandalized by the extent to which the Honorable Chief Justice was prepared to consciously sidestep the due process and even breach the Constitution just to please the President and aid him to execute his unholy agenda to pack the Supreme Court. It is for good reason that Article 144(2) of the 1992 Constitution enjoins the President to make such appointments to the Supreme Court on the advice of the Judicial Council in consultation with the Council of State and subject to parliamentary approval.